Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. At Scaringi Law, one of our largest practice areas is child custody. On August 15th of this year, the Pennsylvania Superior Court ruled on grandparent standing in child custody cases. It clarified that a grandparent can file for custody when the child is at substantial risk of parental neglect or abuse, even if that parent does not have any current custodial rights to the child. Here's what happened. The paternal grandparents attempted to intervene in a custody case involving their grandchild. The trial court dismissed the paternal grandparents' attempt to intervene, stating they had no standing. The paternal grandparents appealed to the PA Superior Court. The PA Superior Court reversed the trial court decision and found that the paternal grandparents did in fact have standing to intervene because the grandchild is substantially at risk of abuse or neglect due to the behavior of the parents. Now, there is a section of the Child Custody Act that allows a grandparent to seek custody of their grandchild if the grandparent can prove, one, the grandparent had a relationship with the child that began with the consent of at least one parent or by court order. Two, the grandparent assumes or is willing to assume responsibility for the child. And three, any one of the following three conditions exist. One, the child has been adjudicated dependent under the Juvenile Act. Or two, the child is substantially at risk due to parental abuse, neglect, drug or alcohol abuse or incapacity. Or three, the child has, at least for 12 consecutive months, resided with the grandparent and is removed from the grandparent's home by the parents. So a grandparent, in order to obtain standing to pursue custody of his or her grandchild, must have had a relationship with the child prior to going into court, must be willing to assume responsibility for the child, and the child must have been adjudicated dependent, or the child is substantially at risk of abuse or neglect by the parent, or three, the child has for at least 12 consecutive months resided with the grandparent and then is removed from the grandparent's home by the parent. So that is the main section of grandparent standing under the Child Custody Act. Now, in the case that the PA Superior Court just decided, the child's parents both had a history of drug abuse. Father also had a criminal history. And the child had lived with the maternal great-grandparents on and off throughout his entire life, and continuously since October of 2015. In 2016, the father filed for custody. The mother and father then agreed via a consent custody order that mother would have primary and father would have partial physical custody of the child. But that wasn't the end of the custody case, because the maternal great-grandparents then intervened in the custody case between the mother and the father via an emergency action. They claimed the child was not safe with the father. The court suspended, in response to the maternal great-grandparents' petition, suspended the father's custody rights, vacated the consent custody order, meaning did away with it, and gave the maternal grandparents sole legal custody of their great-grandchild pending further order of court. Now, the parties in that case agreed the maternal great-grandparents had standing. So the issue of standing for the maternal great-grandparents was not litigated. But sometime later in the case, the paternal grandparents got involved and filed their own petition to intervene, requesting custodial rights of their grandchild. The paternal grandparents stated the child was substantially at risk of parental abuse or neglect, the same standard cited by the maternal great-grandparents when they intervened into the custody case. Now, in this part of the case, the maternal great-grandparents challenged the standing of the paternal grandparents to file and sue for custody, arguing that the child was no longer, or the grandchild, was no longer at substantial risk of abuse or neglect, because the grandchild or the great-grandchild was in the maternal great-grandparents' care at this time in the case and was being properly cared for. So there was no longer a substantial risk of parental abuse or neglect. So in this case, the trial court agreed with the maternal great-grandparents and dismissed the paternal grandparents' petition to get custodial rights of their grandchild, saying the child or the grandchild is no longer at risk of parental abuse or neglect. Now, the paternal grandparents appealed. It went up to the PA Superior Court, and the Superior Court reversed, meaning disagreed with, the trial court, and held this, that the statute says the risk of parental abuse or neglect is this: since parental rights have not been terminated or relinquished, it's possible for either parent to seek custody of the child, and this possibility creates an ongoing risk to the child, even though the child is currently in the care of the maternal great-grandparents who are properly caring for the child. So the PA Superior Court claims this decision will avert a race to file a custody petition between competing sets of grandparents. Now, I'm a bit skeptical of the legal basis for making a decision based upon a theoretical risk of future harm. But in any event, the PA Superior Court has now clarified that grandparents do not need to race to the courthouse to seek custody of their grandchild in the event of parental abuse or neglect, and that grandparents will still have standing even in a case where the other set of grandparents have come in and have taken custody of the child from the parents, and the child is now in the good custody of the grandparents and is being properly cared for. As long as there was parental abuse or neglect, and as long as the parents' rights to the child have not been terminated, courts will allow grandparents to come in and seek custody of their grandchild, as long as at one time there was substantial risk of parental abuse or neglect. So, sorry, it's a little bit complex and involved, but the point is grandparents in Pennsylvania and great-grandparents in Pennsylvania do have the right to intervene in a custody case, to seek custody of their great-grandchild or their grandchild, as long as they can meet certain requirements to show and prove that they have the standing to do so. So custody law is one of Scaringi Law's largest practice areas, and we practice custody law in all 6 of our offices throughout South Central Pennsylvania. If you have any questions about grandparents' rights or child custody rights, give us a call at 717-657-7770. That's about all the time we have today. Enjoy your lunch.